Live TV Talk on your digital device, on Roku, Fire TV, and Apple TV. Download the SVP TV app right now. Check us out every Tuesday on Comcast Cable, Channel 17, 8:30 p.m. And we are live every Friday on Facebook Live, 6 o'clock in the evening. You've got a question? Our attorneys have the answer. So let's talk law with attorney Daryl O'Neill on the SVP TV network.
Welcome to Talking Law with Daryl O'Neill. I'm your host. I got my main man Jerome with
What's
me.
up, Daryl?
Hey man, another day in the neighborhood.
Yes, sir.
Hey, look, I said I got my main man Jerome with me, but look, there's a middle person with us now.
Oh, yeah.
Hello.
So today we also going to have a special guest, Miss Dominique Mayfield.
Yes.
And she's going to talk to us about some bankruptcy stuff. So before we start, we're going to talk about, got to give our shout outs.
Yes.
Shout outs to the West Coast. Shout outs to Little Rock, Arkansas. Shout out to West Memphis, Arkansas. Shout out to Memphis, Shelby County. Shout out to Mississippi. And shout out to the great state of Missouri. Mom, family, Jerome family. Oh,
What's up,
Dominique family.
Oh, yeah.
We all want to say
Yeah.
hi and welcome to the show.
And all the people in the Chapter 13 Trustee's Office for Sylvia Ford Brown.
Hey.
We are so excited that Dominique is here with us tonight, Daryl.
Absolutely.
Glad to be here.
Now we also, if you have Facebook Live, you have YouTube Live, you have the Roku TV, we have the Fire Stick or the Apple TV, or the SVP TV Network app, you can actually log in and you can ask any questions you want live on the air and we'll answer them.
Daryl, we got a Chapter 13 trustee
Man.
in the house. I mean, you can't beat that.
You know, I have
to
to
ask
correct
her.
you.
I mean, one of the
attorney.
staff attorneys for the Chapter 13 trustee,
Yes.
Sylvia Ford Brown.
Yeah.
There's also another Chapter 13 trustee, and it's Jennifer Cruz
That's
Turner.
correct.
And she also has staff attorneys as well.
That's correct.
Yeah.
So today, what we wanted to do is, we haven't done this in a while, and actually, when we've done this, Jerome, it's just been us talking
That's
about it.
right.
And even though Jerome is, kind of expert in bankruptcy,
Okay, Daryl.
we brought the real deal up here today.
The one who called me on the phone and said, "Did you do so and so?"
Yeah,
So
yeah.
we got the
Did you
real
get it
deal.
right?
No
Did you get it
question.
right?
It's no question about it, Daryl.
So, Dominique, all the time we talk about bankruptcy, and one of the things that Jerome and I always talk about, and we always try to make the guests, the audience know is, that it's the fresh start opportunity.
Yes.
I mean, it's a scenario when you got, I call it financially stuck on stupid.
That can be one way of
Bankruptcy
explaining.
allows you to get back on track.
That's correct. That's correct. A lot of times people have some misconceptions of why they should file bankruptcy, but it is truly a fresh start. There's a lot of different chapters out there that you can file. One of the most common chapters is Chapter 13, and I think that's what we're going to be talking about more today. I actually worked for the Chapter 13 trustee, and it's designed for you to reorganize yourself and have a plan so you know what you can do to become afloat if you are underwater.
Well, and Dominic, Jerome and I talk about this a lot, and he gets mad at me when I say this.
Uh-oh.
So, like, I understand you got Chapter 13,
Yes.
but then you also have Chapter 7.
Yes.
And I'm that anti-Chapter 13 person.
Okay.
And again, I think that Chapter 13, and Jerome makes me understand this, and you can help me out, and I'll take yours more so than I'll take
Okay.
Okay.
But Chapter 13, from what Jerome tells me, it has more opportunities and more things that's available to you than Chapter 7.
It's actually a treasure trove of stuff in a Chapter 13 that if you're wise enough, and I tell you all the time, just like chess, so we are chess players
Right.
in Chapter 13 world because it impacts so many different things that when a person becomes in a situation where Dominique and I talked tonight about, we're trying to prevent the train wreck. Because when the train wreck happens, then we got to send the wreckers in and start pulling cars out of place. But Chapter 13 can guide you through those through a maze to get to your fresh start. And that's what Dominique is going to do tonight, is to help people understand all the myths about Chapter 13 or bankruptcy, period. They're going to take all of my stuff away. And I tell people all the time, bankruptcy was never designed to take anything away from anyone. Mm-hmm. It's simply to help you realize that you can no longer continue to operate the way you were operating. Mm-hmm. And we say too in Chapter 13 world and bankruptcy world, it's the man or the woman in the mirror that got you to this point. Mm-hmm. So you got to change your behavior. So what do you think about that?
So Dominique, why would a person, what is it that Chapter 13 brings to the table for people?
Well, let's just talk about a couple of common reasons why Chapter 13s are foul. Mm-hmm. Sometimes, and also talk about Chapter 7 at the same time. Okay. Sometimes
My
people,
thing.
yes, your thing. So let's just talk about a person who is behind on a car payment. We'll start there. So when you are behind on a car payment and you're facing some type of repossession, mm-hmm. Chapter 13 is designed to have certain tools in place where if you file it, you're protected. Mm-hmm. And when I say the debtor is protected, and when they file that Chapter 13, they can basically stop a car from being repossessed. Mm. With a Chapter 7, most of the times, if you're going to file that, you're probably going to have to be current on your car payments. Okay. And if you're not, then again, Chapter 13 is where it has some protection for that debtor.
Well, the anatomy of a bankruptcy filing is, first of all, let's identify the players. The players are debtor, yes. The players are creditor, and then each side is paired off. And bankruptcy is a court of equity.
That's correct.
And so that's how bankruptcy is able to level the playing field, because most of the time the creditors have the upper hand. Mm-hmm. They pretty much dictate what's going to happen, but not so. Okay. But not so. Right. When the Chapter 13 trustee becomes involved, they help level the playing field. And like Dominique was saying, not only can they stop a repo, but they can also force a recovery mm-hmm. of the vehicle after it's been repoed by filing a Chapter 13.
Yes.
Now, well, Dominique, and I guess the one thing I didn't do, and I probably, so I'm going to say I was behind the 8 ball on this.
Okay.
What is it that the Chapter 13 trustee's office do? What do y'all do?
So we administer the estate. Mm-hmm. There's when the debtor makes payments, mm-hmm. they're making payments to the Chapter 13 trustee's office. And we administer the estate and make sure that those funds are dispersed properly. Okay. So we're pretty much the protectors of the money that comes in and make sure it goes out properly.
So you guys are the keeper of the books?
Yes, that's correct.
Now, but do you also, as the Chapter 13 trustee's office, do you guys have the authority to, make deals or agreements with, creditors, or change the way they're going to, make deals or change the way they're going to do business?
Typically, so when we administer the estate, the one thing that we also do is we have communication directly with creditors, debtors, and we make sure that things are done in a certain particular order. Now, as far as deals go and agreements, let's say that there's a creditor who is, trying to ensure that they're protected. One thing that commonly happens, they may file a motion to lift the stay or something like that, which we can talk about in detail. Mm-hmm. But they may communicate with the debtor directly, or we actually communicate with them as well, and we make sure that all parties are in communication with one another. Okay. So when we administer the estate, we also make sure that all parties are in communication with one another, because the judges, they want to see pretty much things resolved. And okay. If it's not resolved, then of course it comes before the court and the judge makes that determination.
And I like the way that Dominique's, how she's describing it now as an estate. And when I talk to my clients, I tell them that from the moment that a bankruptcy case is filed, a new entity comes into being. It's no longer Jerome Payne, but it's Jerome Payne in bankruptcy. So that becomes the estate. So all of the property and everything that Jerome Payne is associated with then pours into the estate, which is what Dominique is saying, that they then become the protector of the estate.
Yeah.
All right. And so that's why it's important that that debtors be completely open and honest about everything, because it determines how the estate is administered. And that's what they do, is that they properly administer the estates.
Well, Dominique, one of the questions I've always, again, I don't really know this, but when I go to a court and the judge is on the bench, I know that the judge's job is to call balls and strikes.
Yes.
He doesn't take a side one way or another. What is the trust? I mean, does the trustee have that same role, or what is the trustee's, real role?
So there are a few things that the trustee's office does. We have to make sure that the plans are able to be confirmed. Okay. So we talked about with the Chapter 13, the debtor has to have a plan that will work. So we're going to look at that plan, and we're going to, once the debtor says, okay, well, this is what I want to do, this is what I think I can do, we're going to look at that plan and see, okay, well, does this actually work? And if it doesn't, then we end up filing different things such as objections or communicating with debtors counsel and getting to a point where the plan can be confirmed or it works in a sense.
Now let me back up for a minute, because I want to break down what you said, a couple of things what you said.
Okay.
Number one, what is a plan? I mean, what are you talking about when you say a plan?
Okay, so we talk about when someone is filing a Chapter 13, they have to, one of the requirements is that they have to submit a repayment plan.
Okay.
So with the repayment plan, let's still talk about them being behind on their car. They're going to complete the plan, putting in specific information of what debts they can pretty much rearrange to get to a point where they can, by the end of the bankruptcy, one, they'll get a discharge, but two, that they are going to be above water in a sense. So if they're behind on their car note, if they're behind on a mortgage, if they have different type of contracts such as a lease, and they're trying to say, hey, I could not pay that on time, but now I want to make sure that I can actually get it to a point where I can be current, in a sense. They're going to submit a repayment plan that allows for that to happen. They're going to list all of those creditors in that plan where they want to pay back. And then after they do that, there's going to be a plan payment that they have to pay. And they have to pay that through the life of that bankruptcy.
Okay.
So that's pretty much what the plan does in a nutshell.
Now, so now when you put that plan together, does the debtor along with the creditor and along with the trustee put that plan together, or does the debtor says, hey, here's the plan I'm proposing, and everybody else determine whether or not they like it or not? So
the latter part, the debtor proposes a plan with hopefully the communication with counsel. If they're doing it alone, it becomes a little difficult, but they can have that option. So with the hope or help of counsel, they put a plan together, say, hey, this is what I want to propose to you. And it gets to our office. And if we look at it and we say, you know what, this is not going to work, then we will reach out, make comments, or even make objections and explain what concerns we may have. The creditor has the opportunity to do the same thing.
So I'm just, again, don't do 13.
No,
yes.
So that's good.
I'm trying to be
That's
the
good.
audience. I'm trying to
That's
ask
good.
the questions
Right.
that they would ask.
That's good.
So now the debtor says, hey, here's my plan.
Yes.
But I don't really make enough money to finance that plan. Then somebody's going to say that ain't going to work.
Yes.
Not somebody. Sylvia Brown's office is going to say.
The trustee's office
That's not going to work.
is going to say that it doesn't work.
Right. But also the trustees will say that doesn't work, but this will.
Oh, so that was my next
Yeah,
question.
but this will,
Okay.
right.
So
right.
then you look at it and say, okay, that is not going to work.
Right.
well, here's what we propose. Now, if they have too many things, do you propose that they get rid of something, or?
Sometimes it does get to that point. So the one thing that happens, we just addressed the plan that the debtor has to propose. Another thing that happens in the Chapter 13 is you have to have a hearing where the trustee's office communicates with the debtor and counsel if they have it. And it's called a meeting of creditors. And this is the opportunity where we talk to the debtor and we get the information that we need answered. And we also talk about, sometimes some trustees will actually talk about different reasons, why a plan may not work, or they will again object to it, and then we talk about what could actually work. So it's an opportunity for that. They call it a meeting of creditors because it also gives an opportunity for creditors to appear. However, a lot of creditors will just file different type of documents instead of appearing at that actual hearing. But that's where the next step gets into play, where after you file your plan, you actually get an opportunity to talk to the trustee's office.
Okay. Go ahead, Jerome.
And so the trustee has this computer program called Plan Calc, and what that does is, and I don't know all of the inner workings of it. So Dominique's going to tell us how it actually works, because it appears to be magic to us.
Well,
but anyway,
I don't know if it's magic.
It's magic to us.
It can be magic to debtors' attorneys, yes. And the reason why, so in the Western District of Tennessee, we have a system that allows the debtor's attorney to log in and actually see, after they've proposed a plan, they can look into the system, and we've actually, you can kind of put it as a calculation. So a calculation format of what the debtor has proposed is available to that debtor's counsel. And they can see in our system what our concerns may be, and also what would be needed to make a plan work. So it's a tool, I'll describe it that way. It's a tool that can be beneficial to a debtor. It's a tool that can be beneficial to a debtor's attorney. And they can basically format their plan by using that system.
So I like that.
One more thing there. One more thing. So bankruptcy plans can be 12 months, 24 months, 36 months, 48 months, or 60 months. So sometimes the debtor's counsel will propose a plan that's not long enough to satisfy.
That's one of the questions.
Right.
Okay,
and so what this program does, when you plug it in there, and so you got a 48-month plan, but the debt will not be satisfied within that 48-month period. So the trustee's office then suggests possible solutions to that by extending the plan in order to satisfy, because the maximum time is supposed to be 60 months.
Right.
And so it may take another 12 months in order to satisfy all of the secured debt. And one thing we did not talk about, Dominique, was we talked about the debtor, we talked about the creditor, but we did not talk about the unsecured creditors.
Yes.
And we did not talk about the secured creditors.
Yes.
Because you all are actually the lawyers for unsecured creditors somewhat, aren't you?
Well, we are the attorneys for the trustee.
Okay.
But we administer, and we have certain duties that we have to abide by, and we have to make sure that certain things are protected. And so there's a list of different duties that we have to abide by, but it all ties into, again, the plan being able to work. So I guess a consequence of the plan, needing the plan to work, we, in a sense, there's certain people that are you look out for. I say it in that way. But ultimately, we are, again, the attorneys for the trustee, but we will make sure and ensure that the plan works and that the laws that we are governed by are abided by. And I think that's where Jerome was getting at, as far as certain people being protected than others. The secured creditors, in a sense, have some protections towards them by people that represent them, but also because of the way that the bankruptcy system is designed.
You know, I always got to ask these tough questions. You know, somebody is the keeper of records. and I would assume that that's the trustee's office. So somebody is out of, who knows the percentage? What percentage of people that file Chapter 13 successfully complete the Chapter 13 plans?
That's Dominique.
Well, I wouldn't say it's me directly. I can get the answer to that question. I don't have the statistics available to me now, but if I had to guess, because I do have a background working as a debtors counsel as well, that in different districts it does vary. A lot of times it's ultimately going to depend on what the debtor does. A lot of times a Chapter 13 plan, the one reason why you may not like it is because you have to be in it for a number of years.
Right.
So the average time is 3 to 5 years. And if you think about that, you never know what's going to happen in a year. So 2 years down the road, a debtor could lose their job.
Right.
And if they lose their job, that may hinder the plan from being able to work. So sometimes plans just end up not working ultimately for the 5th or 3rd year is because certain circumstances happen. You know, life happens. Like they say, life is lifing, you know. So sometimes that can interfere with the success of a plan. But to just answer your question broadly, I'd say that there is a low percentage of plans that are fully successful throughout that period of time. But sometimes when the debtor's counsel steps into play, they can make sure that they can push the debtor along for there to be a successful plan. Yeah.
Yeah, I mean, and you hit it on the head. I mean, so some of those are my concerns about the 13.
Yeah.
I mean, the 13 of it. So here's what you're asking, okay? And I guess this is why I have the problem.
Okay.
What you're asking is for undisciplined people to become disciplined. Okay.
And so there. That's what the Chapter 13 trustee
I know, but
will do is to hold their hands and help direct them in the direction so that they can be successful.
Well, let me add to that,
Okay.
because not all debtors are undisciplined, but there are things.
Thank you, Dominique.
There are protections that will allow them to be disciplined, such as one reason why Chapter 13 is unique is they call it like a wage earner plan, and with that term, we will issue, or the court will issue, wage orders. So let's say a debtor has a job, and if they're not disciplined enough to make a payment monthly, you know, there's a employer that will deduct that money because of the wage order that a court has issued, and it's going to discipline them because they're going to automatically have that coming out of their check, and all they have to do is go to work. And they're going to want to go to work because they're going to want to continue to make sure they have that car or that house.
Well, but what I see so often, and maybe is I see these motions to dismiss because somebody is not financing their plan.
Yeah.
And so if they're not financing their plan, then are we to assume that they don't have a job?
Well, that can be, I would say, accurate assumption. Either
Okay.
they don't have a job or they are in that category of undisciplined people, like you say.
Well,
There may
also,
be not,
go ahead.
yeah,
I'm sorry. Go
No,
ahead. But also too, and what I love about what I love about the law period is noticing practice, because many times the fact that the motion to lift stay has been filed or motion to dismiss filed really wakes the debtor up that you better get on your job, otherwise you're going to wake up one morning and your car is going to be gone,
Yeah.
or you're going to wind up being evicted. So many times the motion to dismiss is really a wake-up call.
Yeah.
Because, you know, like Dominique said, and so before recently, a lot of our people in this area were working for these payday companies, little temporary services, and so you can't really get a track record working for these temporary services, and many of them will not deduct the money from their paycheck. So it is left up to the debtor to do it, and the debtor just changed jobs, and so, but when they get that motion to dismiss, that'll let them know, hey, you better get on it.
And I'll even add this one point too. Aside from undisciplined debtors, sometimes it's just lack of communication. You have some debtors that may not communicate with their counsel,
Okay.
or they just don't communicate, period. So let's say they are working, but they may have changed jobs, and they haven't communicated that to the court, they haven't communicated that to our office or to their attorney. So then they end up being dismissed in a way because we don't know that they have a new job. Let's say that a debtor moves. That sometimes becomes an issue because they don't communicate to their attorney, and their attorney can't locate them, or they change numbers.
Right.
So it just takes pretty much everyone communicating with one another for that plan to work.
Yeah, I mean, and I get that. Again, I'm being over the top
Yeah.
because that's just what I do anyway. According to Jerome, that's all I do is over the top. But I mean, so
There's some perks to both. There's some perks to 7s. There's some perks to 13.
yeah.
I'll say that as a middle ground.
Look, I mean, and I know, I mean, so, and I think, and Jerome, you can correct me wrong, I think the date was around 2004 that the bankruptcy system
2005.
2005.
2005.
Yeah.
The bankruptcy system changed.
That's right.
Yes.
And it used to be Chapter 7 friendly until 2005. And in 2005, it became Chapter 13 friendly and less Chapter 7 friendly.
And it was designed to do that. The credit card companies had a big say in the law being changed.
Yeah, I think there was some abuse that they were trying to make sure that didn't occur. So they enacted a lot of different things in 2005 to prevent abuse from happening within a bankruptcy.
Well, I mean, but abuse is a disgusting word
Well-
because because the reason why I'm here, okay, again, I'm just the slow guy, but the reason why I'm here is for one or two reasons. One is I have abused the system for so long. That's what got me in financial problems. I've had all these financial opportunities. I ain't do well with them, and I abused that. And now I'm here. I need your help.
And sometimes it's just circumstances, like we talked about at the beginning, life. So
Absolutely.
what if somebody got a divorce?
Yeah.
What if somebody got a surgery?
Yeah.
You know,
Or a spouse died.
spouse
It was
died.
two of them in a
Yeah.
household.
Yeah.
Yeah. So there, yeah. So and usually.
Or business didn't work.
It's a system that was designed to be a backstop.
Yeah.
It's a safe harbor
Right.
for someone who meets an unfortunate situation.
Right.
And they need just a little assistance to help them
Yeah.
over the hump.
Hey, well, let's look. Time has gone.
You see what I
by.
did with every single
Yeah,
week?
time has gone by a lot. But Dominique, in closing, Dominique's going, tell them why they should be willing to look into the bankruptcy
Yes.
system if they're having a problem.
Yeah.
A lot of times people think when they hear the word bankruptcy, it's negative, like I need to run away from it. But really, I think that debtors need to know and people need to know that, again, our main thing that we talked about is life happens. So if you need a fresh start financially, bankruptcy, you want to actually just look into it. Whether you're talking to someone, consulting with an attorney, look into it to see if it can make a difference in your life, because it can make the difference of you being underwater and coming above water financially. So
And most of us will do a free consultation, so it don't
Yes.
cost you a dime to get the information that you need to make the right decision.
All right, y'all. Man, look, another day we had a trustee here or somebody from the trustee's office that could answer any questions that you had. You ain't take advantage of
Sure
it.
did.
Dominique, we appreciate you being on the show.
I'm glad
We
I was
want
here.
you back.
Yes, I'll come back. I'll
and
come
as
back.
always, Jerome, thank you for being on the show.
All right, brother.
Thank you guys for watching. We'll
Thank
see you back
you.
next week.
Can you actually imagine hosting your next event at the all-new SVP Banquet and Event Center? Yes, spacious, beautiful venue with plenty of parking, located in the heart of East Memphis. Let